What's a HIPAA release and why does a caregiver need one or why does a recipient of care need one? Well, here to talk with me about that is Harry Margolis, who is author of Get Your Ducks in a Row. Harry, welcome.
It's always good to be back with you, Bob.
Pleasure, such a pleasure. So we're here today. This is part of our continuing series looking at legal and financial documents that the caregivers and recipients of care need. Right now, we want to focus on the HIPAA release. What is it and who needs it and why do we need it?
Well, so it's a very important document. So, of course, HIPAA stands for
Health Insurance Portability and Accountability Act.
exactly. Thank you very much. So it's a great law. It protects your data basically, so that people aren't. It protects your privacy, and from that point of view, protects your autonomy. So medical personnel are not supposed to be talking about your private matters without authorization from you. And in most cases, that's a great thing. But in some cases, it can get in the way. So, because you, in most cases, would want your family members, if you're unable to communicate yourself, would want your family members or other trusted people to communicate for you. And and there's sort of two sides to this. There's the providing of information, and there's the receiving of information. And sometimes these get mixed up. So. So what HIPAA bars is the healthcare personnel or institutions sharing information with other people, but it doesn't bar them receiving information. So talking about their sharing information, if you are ill or you're hospitalized, you probably want that information to be shared with your loved ones or with particular ones. And especially with your healthcare agent. Now, most state laws say that if you name a healthcare agent under your healthcare proxy or power of attorney, that in effect is a HIPAA release, meaning that the medical people can talk to them. But we always include a separate clause in our documents that explicitly grant a HIPAA release to that agent. But you may want other people to be able to receive information too. So while you want, as we discussed before, you want one person to be the point person on making medical decisions and to be able to speak for you, you may want any of your family members to receive information. So we always recommend executing a broader document, a HIPAA release, to anyone you would want free to be able to see your medical records, to talk to medical personnel, whether it's everyone in your family or, again, other people that you want to be able to receive that information. You can execute a HIPAA release permitting medical professionals and institutions to share information with them. So that's the receiving information from the medical profession. Now, there's no bar on the medical profession receiving information from anybody. However, sometimes people are really busy. So if you're in an emergency room or if you're in a hospital or even your doctor or their staff, they may be really busy and not want to bother with talking to too many people. And sometimes they put the HIPAA up as an obstacle to them even receiving information. And that can be a problem because there could be really important information they may need to know. They may need to know about your medications. They may need to know about what exactly happened. They may need to know what your status was before whatever the incident was is put you in an emergency room. Because when you present to an emergency room, whatever state you're in, which may be groggy or incapacitated or confused, they don't know that that's not your normal state, that you're suffering from dementia or something like that, and they may jump to assumptions which may be wrong. So it's important that that HIPAA release be available just in case. Now, I don't think we haven't run into this issue as much recently as we did when HIPAA was first passed. So I think the medical profession has got it basically, that it's really a one-way protection, not the other way. But still, just in case you run into somebody, it's good to have that. Run into that problem.
And from a practical perspective, it seems like some hospitals, some doctors, there's a gray zone. Some doctors will maybe talk to the next of kin, even if there's no HIPAA. Other institutions may say we want the HIPAA before we'll talk to you. And so, from a practical perspective, people should expect a whole range of outcomes when they're dealing with this issue.
That's absolutely correct. I think, I mean, the reality is, again, I think institutions and medical personnel have loosened up a bit. Then again, there's been an evolution since when the law was first passed, when people were really worried about liability. And I think they're less worried today. I mean, there haven't been a lot of lawsuits against people for breaching HIPAA. And so if it makes sense to communicate with others, they do in most cases. But still, I think it's still good to have that as insurance in case you run into somebody who's going to stand on ceremony. And it can also help if there's issues within families where the healthcare agent is not sharing information and is telling medical people not to talk to you or talk to other family members. If you want complete transparency and cooperation, then it's good to list on the HIPAA release everybody you want to receive information. And if there's a dispute about that at some point in the future, it's pretty clear on the HIPAA release who you wanted to receive the information.
So, from a practical perspective, again, where do I find one? How much does it cost to complete? Where should I store it? Who should have access to it?
So, I believe you can probably find them and download them online. In most, as with the healthcare proxy and the medical directive, most estate planning attorneys are going to provide these now as part of the complete group of estate planning documents that they will prepare for people. So along with a will, durable power of attorney, a healthcare proxy, or durable power of attorney for healthcare and a medical directive, they'll also prepare a HIPAA release so that you can basically get the whole package together. And there's no extra cost for that. They don't really charge per document. They charge for doing the estate plan.
So we've covered a lot of ground, Harry. I think we've covered the landscape with this topic. It's part of a continuing series. Next up, we'll be talking about the durable power of attorney for financial matters, and we'll be going through all the terms that people may have become acquainted with, springing powers and et cetera, et cetera.
Yes, et cetera, et cetera. Spring powers are really interesting because healthcare proxies are by their nature springing because they only take effect when a medical doctor has entered your medical record that you're incapacitated. Most powers of attorney, however, take effect immediately on being signed, and I'll explain why that's better.
All right. Harry, thanks again for sharing your knowledge and wisdom with us. It's greatly appreciated.
My pleasure, Bob.